This video will walk you through the legal process of getting a divorce in California. Who can file? The first step is to determine where and when you can file for a divorce in California. To get a divorce in California, one spouse needs to have been a resident of California for at least 6 months and at least 3 months in the county where you are filing. If you or your spouse don't meet this requirement, you can wait until you do. How do you file? The next step is to file a summons and divorce petition, along with filing a summons. The spouse that files first is called the petitioner. What can you request in your petition? In the petition, not only are you asking for the court to dissolve the marriage, but also make orders regarding the division of property, like real estate, money and bank accounts, retirements and investment accounts. Division: who will pay of what debts that were acquired during the marriage, spousal support, and in families with minor children, child custody and visitation and child support. After you've filed the petition in court, your spouse needs to be served with a petition. This means they have to be given a copy of the petition and summons in person, but not by you. It needs to be delivered by someone who is 18 years or older and who is not directly involved in the case. This could be a friend, family member, a sheriff, or a process server. The spouse has 30 days to respond and give their wish list for the divorce. This is called a response marriage domestic partnership. They will file this with the court and serve the petitioner. They are now called the respondent. Each spouse also has to file something called preliminary declarations of disclosure. The petitioner has to file this within 60 days of filing their petition, the respondent within 60 days of being served. This is basically a list of your assets, your debts, your income, expenses, and taxes. If the respondent does not file their response within 30 days of being served, the petitioner can file to request a default. This means that the petitioner can ask the judge for a judgment based on what they asked for without the respondent's partitions. If the respondent does respond, it becomes a contested divorce. Contested divorces can end in 2 ways. Both spouses can come to an agreement on property, debt, custody, and visitation, child support, and spousal support. Or it can go to trial, and a judge will make a decision on all of those issues. In all situations, default, agreement, or trial, to complete your divorce, you need a court judgment. A judgment will be signed by the judge and will have a date of termination. This is the date the marriage is legally dissolved. For more information, head to www.inlandlegal.org.